Well, then if we want to get started and we can kind of triage as we go. Welcome, everyone. My name is Jake Muzadis. I'm the lawyer chapter fellow here at ACS. I use he, him, his pronouns. We're so glad that you all joined us today. Just a few quick technical notes. If you all want to submit questions as you go, you can use the Q&A app at the bottom. Just type in your questions and send them in, and we'll reach a question and answer point a little ways through the program. But otherwise, I'll turn it over to April Day, who is a member of our board of directors for our ACS At-Large chapter. Take it away, April.
Hello, my name is April Day. I use she and her. Welcome to this event during Women's History Month. This event is being hosted by the American Constitution Society At-Large Lawyer Chapter. Although ACS chapters can be found in almost every major metropolitan area and law school, there are some people who are unable to join one of our existing chapters due to factors such as physical location, work schedule, or disability. This sounds like you, or if you would like to join us, please join our chapter. Our events are mainly online. This event has been approved for 1 hour of California MCLE credit. If you would like to claim your CLE credit, please send an email to lcemails@acslaw.org with your bar number and the state you're seeking credit in to receive your certificate of completion and feedback form. Put at-large CLE in the subject line. CLE written materials are available on this event's webpage on the ACS.org website. The American Constitution Society is a 501c3 nonprofit, leading progressive legal organization with more than 200 student and lawyer chapters across the nation. ACS does not endorse any candidate or political party. Views expressed. Please join me in welcoming Professor Kathryn M. Stanchi. She is the EL Core Professor of Law at the University of Nevada, Las Vegas, William S. Boyd School of Law. Professor Stanchi has dedicated her academic career to teaching students how to be good lawyers. She is the author of numerous articles on persuasion, rhetoric, feminist theory, and writing, as well as 2 books on persuasion. She co-edited a book called Feminist Judgments, Rewritten Opinions of the United States Supreme Court. The book looks at 25 key U.S. Supreme Court opinions using a feminist lens. She will discuss that book with us today. Now I turn it over to the professor.
Hi, everyone. Thank you so much, April and Jake and the American Constitution Society for inviting me to talk about this project, which is near and dear to my heart, and in celebration of Women's History Month. I know that there's been a lot of other stuff that has overshadowed this month other than women's history, but maybe this will provide a nice distraction for people from thinking about viruses and other things. So thank you so much. So as April said, I am going to talk to you about feminist judgments. First, hopefully you're able to see my screen. What is the Feminist Judgments Project for those who don't know? Well, from the original US book, which was published in 2016, it's really exploded. The project started actually in Canada and then was followed by an English volume, and then the US volume was third. And now we have projects in New Zealand, Australia, India, Africa. There's a nascent project in Mexico, and I hear tell possibly in Pakistan as well. So it's been amazing to be a part of this movement, really. So our major goal of the project is to rewrite major judicial decisions from a feminist perspective. The US project started with 25 Supreme Court cases, but we've branched off into a series of books that include reproductive justice, family law, which are coming out very shortly, tax, which is already out, torts, property, healthcare, corporations, criminal law, trusts and estates, and immigration. And I hope more to come. So the basic touchstone of feminist judgments is that we rewrite judicial decisions from a feminist perspective, but we want those decisions to look like law. This is, without a doubt, an academic project, but it's also a rhetorical project because both Professor Linda Berger and I are rhetoric specialists. We're writing and language people, so we very much wanted the project to be a part of that. So as part of that, all our authors, when they are rewriting decisions, are bound by the law as they would have been if they had been sitting at a judge at the time of the original decision. So to the extent that there is precedent in place, they are bound by that precedent just like they would be, whatever court they were sitting on. Obviously for SCOTUS, the Supreme Court can always overturn law, but if the authors wanted to do that, they had to grapple with that law. They couldn't just ignore it. The other sort of requirement that we made on our authors, and we continue to make, is we ask them to write as a judge, not as an academic. We want the judgments to have a judicial tone and a judicial format. We want them to essentially sound like law. And I'll talk a little bit later about why that's important to us from a teaching perspective. But that is something that is a thread that runs through all of the projects internationally, that you have to comport yourself like a judge sitting at the time of the original decision. And that holds true for people rewriting 2016 decisions. It holds true for people writing 1870 decisions. That's just the bottom line requirement. So one of the goals of this project was that the three editors got together and talked about how much our students and we came to law because of the law's potential to enact social justice. And for some of us, our disappointment by how it hasn't been used to its full potential for that end. So when I talk about feminist judgments, I want to say at the outset that we did not tell our authors how we defined feminism. We recognized that there are many different kinds of feminisms, and we wanted there to be room for those in this project, but we did want everybody to be on board with feminism defined very broadly as a movement for social justice. We very much wanted these books to be intersectional. So to the extent that the cases raised issues of race or class or sexual orientation or sexuality, we wanted that to be part of our feminism. So that was very important to us, along with very insistent on having a diverse project from a number of levels. Authors who were diverse by race, by status in the legal academy, by seniority, by experience. We really tried to have a lot of different voices in this project because, as I'm going to talk about in a second, we had certain goals for the project, and one of the main goals could really only be filled by having a very diverse set of authors. We really viewed the project as kind of a step-by-step project. We have a grand endpoint, I think, but it isn't a radical transformation of our basic laws. We're not changing the Constitution. We're not changing national statutes. We're just setting out to show whether these laws that we already have are susceptible to a different interpretation. So that brings me to the goals of the project. Very first goal was that we wanted to show that feminist decisions, a feminist jurisprudence, was and is possible with the law we have now. Again, that we wouldn't have to amend the Constitution, we don't have to change the Constitution. It's really just a matter of viewing the law from a different perspective. We also, as a corollary to that, set out to prove that legal decisions depend greatly on the bias of the people making those decisions, as much as they do on stare decisis. So many times we read judicial decisions and they appear to be the inevitable result of what the rules are. And we really set out to show that those decisions were not inevitable, that actually there were different ways to see the rules to arrive at a different kind of law. Finally, and this brings me back to the diversity part of the goal of the project, Bridget, Linda, and I all came to the project with the idea that judicial diversity was important, but I think none of us really expected how significant the difference would be. That having diversity on the bench is certainly an ethical imperative. We think the judiciary should reflect society. But what the rewritten decisions showed us when we reviewed the manuscript was how much that matters to the substance of our jurisprudence, how much the law could have been different if we'd had a less homogeneous bench. So just to give you some idea of what the original volume covered, the original volume was entirely Supreme Court cases and largely cases with a direct and obvious connection to gender: sexual harassment, reproductive justice, Title VII cases, pregnancy cases, cases about sexuality and Lawrence v. Texas and Obergefell, gay marriage, the sodomy laws, things that very, very obviously implicated gender. The series, though, have really branched out, and this is part of kind of the goal that has evolved from the project, which is to show that all law has the susceptibility to be remade from a feminist perspective. So you'll see some usual suspects here on the series list: U.S. v. Windsor, Marvin v. Marvin, Michael H. v. Gerald D. In family law. But also you'll see some where I think gender and social justice may be less obvious: Paulsgraf, Tarasoff, Kelo. So we really are trying to bring out and show that sometimes, a lot of the time, it is a matter of your perspective to see the implications of gender or race or class in a particular context of law. So just some background on the original volume. We ended up with 15 rewritten majority opinions, 5 dissents, 4 concurring opinions, and 1 partial concurrence and dissent. Interestingly, of the rewritten majority opinions, they were split almost evenly between those that changed the ultimate ruling and those that changed the reasoning and not the ruling. So you notice that there were some cases on the list from the SCOTUS volume that were considered to be triumphs of social justice or gender justice: Roe v. Wade, Loving v. Virginia, Obergefell. So a lot of didn't change the outcome, but significantly changed the reasoning or the basis for those cases. So as an example, Kim Mutcherson, in her rewrite of Roe v. Wade, rejected the original trimester approach and grounded her opinion in privacy and equal protection. Laura Rosenberry in Griswold grounded Griswold less in the penumbra reasoning of the original and more in equal protection, treating the the genders differently, based usually on bias and stereotype and not much more. So I'm going to talk a little bit more later about the implications of those changes in legal grounding, but those were some of the threads that ran through the original volume. So along those lines, one of the more interesting things that Bridget, Linda, and I and our authors are starting to think about now is thinking about how the law might have changed historically if these cases had actually been the cases that were originally decided. So one of the things that we haven't done, because it's just been logistically so difficult, is to kind of start with an older case and see how the changed feminist judgment might have changed the later cases kind of in a domino effect. So right now we just have all freestanding, we may have McDonnell Douglas rewritten from a feminist perspective, but the later Title VII cases wouldn't reference back that original feminist judgment. They would just do a freestanding Title VII feminist judgment of their own. And we've only just started thinking about how we might evaluate or take on the project of thinking about how the law might have looked different if the precedent had been different. So along those lines, I wanted to talk a little bit about both the oldest case in the original SCOTUS volume and one of the newer cases. So the oldest case in the volume is Bradwell v. Illinois, which I'm sure many of you are familiar with, but basically involved a woman who was denied admission to the Illinois bar solely because of her gender. The case is from 1873. So in the original version, the Supreme Court upheld the denial of the license to practice law based on a very narrow interpretation of the 14th Amendment, which had at that point been newly ratified. Bradwell, the case came out I think a day or two after the Slaughterhouse cases, which were the very first cases interpreting the 14th Amendment. And Bradwell is probably most famous for a concurring opinion by Justice Bradley, in which he waxes eloquent about the proper place of the female sex, which is unfit in his view for the occupations of life. So Goldfarb, this is one of my absolute favorite opinions in the book, and that's a real testament to Professor Goldfarb, because she was one of the authors who pushed back a little bit on this requirement that she stick precedent, because of course from the outside it looked like, oh my God, 1893, how am I going to change this? What feminism was saying in 1873, but she rallied and just dug into the historical record, both surrounding the adoption of the 14th Amendment and the historical documents relating to women's suffrage, and found a tremendous amount of material that was available to the court at the time and part of the public record at the time that could absolutely have supported her position. She ended up writing as a dissent to the Bradwell decision, but found after she had done some digging that the arguments and the support for those arguments were there, but simply ignored or overcome by the justice's belief about the proper place of women in society, and frankly, the fear of a broad 14th Amendment giving newly emancipated Black people too much power. So it was really a tour de force. I commend the opinion to you if you have a moment to read it. So one of the things that was so amazing to me about Goldfarb's dissent was how she made me, who had, read the 14th Amendment a bazillion times before I edited this dissent, she made me realize the beautiful breadth and radicality of that amendment, particularly for the time in which it was ratified. And the way that she talks about it having this tremendous potential to equalize our society, and how these three cases, the Slaughterhouse cases and the Bradwell case, just strangled it. In her view, she says, you know, they smother the clause just as it was taking its first breath. You know, these powers that the majority read out of the amendment are precisely those that it was designed to achieve. And so if nothing else, it made me reappreciate the 14th Amendment and what it was meant to do. She also directly answers Justice Bradley by looking at all the women in the recent history who had demonstrated their skill as laborers and their willingness to step in when needed. You know, slave women, frontier women, women who stepped in while men were fighting the Civil War. That this kind of rarefied, narrow view of the proper place of women was a bias of these 9 justices who had only very narrow experiences with women, largely white, upper middle class, wealthy women who, you know, like their wives, who stayed home and had their children and watched their children and were delicate and what have you. You know, nobody was out there digging ditches if you were married to a Supreme Court justice, but that doesn't mean those women didn't exist. So one of the interesting things when I edited the manuscript, when all of us edited the manuscript, was seeing that over 100 years later, that reasoning by Justice Bradley pops up again in a later case, Johnson v. Transportation Agency of Santa Clara. Now, Johnson was decided in 1987, over 100 years after Bradwell. And it was the first Type 7 challenge to an affirmative action plan based on gender. For those who don't remember it, it involved a woman, Diane Joyce, who was appointed to a road dispatcher job, which was a skilled trade job in the transportation industry, was never held by a woman in the Santa Clara agency. The transportation agency had this incredibly Byzantine process for evaluating candidates for this skilled position. And the sort of interesting thing was that they ended up with this mathematical score that everybody got. So of course, you know, numbers, it looks objective, but it was the result of the subjective tally of 3 people who had interviewed all these folks and evaluated their personnel records and their seniority and all of that, and somehow come up with a score. Joyce ended up with a score of 73, and Paul Johnson, who was the plaintiff in the case, ended up with a 75. Joyce was chosen because of the agency's affirmative action plan, and then Paul Johnson sued. So Justice Brennan wrote the original Johnson and found that the affirmative action plan of the Transportation Agency was fully consistent with Title VII, but he did so over a dissent by Justice Scalia, whose reasoning harkens back pretty clearly to Justice Bradley's reasoning in Bradwell, where Justice Scalia basically says, I don't believe that women aren't in these skilled trade positions because of discrimination. They're not in these skilled trade positions because they don't want these jobs. They essentially don't want to get their hands dirty. Really interesting kind of equivalence there between those 2 opinions, otherwise separated by a century. So what the Feminist Judgment does, it's written by Deborah Rohde, and she took a very interesting approach to the project, which frankly we weren't expecting, but we rolled with it. She attempted to craft a decision that, in her view, having clerked for Justice Marshall, would have maintained the majority of the original decision. So she didn't make very many changes to the original decision, but she made some small changes that might have made a big difference in the later affirmative act cases. So one of the things she does was play with the facts. She highlights and expands on the fact that Joyce achieved her score of 73 despite the fact that two of the three men on her evaluation panel, the ones who came up with this score of 73, were people that she had filed grievances against previously because of sexual harassment and discrimination. So these two men had deprived her of important job equipment. They scheduled her interview at the same time as a mandatory safety training. They called her names. You know, she had numerous obstacles in her way. And frankly, the fact that she got a 73 from two of these guys is uncanny. And Rohde emphasizes that in her facts, that under these circumstances where she has all these obstacles in her way and that Johnson does not have, you know, it almost suggests that she was more qualified than he was. I mean, you know, at least as qualified. So she really uses the facts to undercut this idea that 73 and 75 are exactly what they look like. She was just 2 points lower than him, and instead emphasize the closeness of that score given the circumstances under which she found herself working. She also directly answers Scalia's argument about women not wanting to, quote, shoulder, pick, and shovel. And to do this, she dug through voluminous records to show that women applied for these skilled trade jobs in great numbers, but were kept out by discrimination. And in fact, this was why the Transportation Agency had created the Affirmative Action Program in the first place. And again, much like with Bradwell, but even more obvious, all of this evidence was easily available at the time, and much of it was in the briefs submitted to the Supreme Court in Johnson. So what the Bradwell and Johnson cases say to me is they really challenge me to ask this question. Goldfarb's Bradwell, with her expansive view of the 14th Amendment, what if that had been the majority in 1873? How might our laws and history have been different? How might the 14th Amendment have been interpreted differently? You know, we're still in an argument over the Equal Rights Amendment. If Goldfarb's Bradwell had been the majority opinion, maybe we wouldn't need Equal Rights Amendment because we'd have the 14th Amendment. You know, similarly, would Justice Scalia have felt free to espouse that biased viewpoint about what women want to do if it had been explicitly rejected over 100 years before? Justice Scalia's dissent for this women don't want to shoulder, pick, and shovel, no citation, no backup for that, just uncited proposition. You know, would he have felt the need to justify that a little bit more if over 100 years ago the court had said, you know, hey, look at all these other women doing this dirty work. You know, your viewpoint is narrow. Similarly, you know, when I spoke earlier about Griswold and Roe and how the feminist judgments were grounded more firmly in equal protection, you know, would it have been as easy to whittle away at those reproductive rights if they had grounding not in this sort of difficult to wrap your hands around penumbra and more firmly grounded in the Equal Protection Clause? So finally, I wanted to talk a little bit about teaching with feminist judgments. Bridget, Linda, and I have 2 articles out there from 2019 that include multiple authors talking about how they teach with feminist judgments. I think for me, that's one of the most important things that has come out of this project is the ability to show students how different law could be, how much potential, unrealized potential law has to achieve social justice. So some people have freestanding courses on feminist judgments. Other people use individual cases in their writing or their doctrinal classes. Others direct students to the feminist judgments as ways to stimulate them to develop arguments or develop new lines of reasoning. And it does really help to have the judgments written in legal language when you send the students there, because it's one thing to send students to a scholarly article, and there are many wonderful scholarly articles that challenge the law and criticize the law, but for students who are trying to understand how to make those scholarly arguments in the context of the practice of law or as a judicial clerk, I think it's a lot more helpful to have it in that judicial language, so the kind of gap of transference from theory to practice is not so large. And so I'm going to tell you that we have a Feminist Judgments website. It's on UNLV website server. And as much as I would love you to buy these books, and I would, I can tell you that there, right on the website, information about how you can use a single or 2 or 3 cases from a volume, and the students are not, it is not necessary for them to buy the whole volume. Now, I will tell you that the series, we negotiated with Cambridge to have the book be reasonably priced for a law text, and the series even more so. The original Feminist Judgments has 25 cases, the series 8 to 15, quite a bit cheaper. Even if you don't impose that on your students, and I totally get that. You know, I know law book buying is, the prices are really out of control. As long as your library has access to Cambridge Online, students can download PDFs of the feminist judgments and have access to them without expending a dime on the student's part. And I think the access to Cambridge Online is quite cheap as these things go. So as much as I would love for you to buy the book, you don't have to in order to teach with feminist judgments. And in fact, a couple of the doctrinal teachers who talked about teaching with feminist judgments in these 2 articles talked about how they give the students the original version and the feminist judgments version of an opinion without telling them which one is the feminist judgments, and sort of equalizing the format so that it's hard to tell from the format, and having a discussion about which is the better reasoned. Can you tell which one is feminist? How is it that you can tell? What do you think the differences are here? Are they important, etc.? So it's really quite fun to teach with these, because it really does stimulate students to think outside the box about the law and its relationship to social justice. And if you have any questions, here are all 3 of the editors' email addresses. We welcome your questions. We welcome input. We welcome criticism. Volumes have been reviewed numerous times, some rave reviews, some criticisms, some sort of cautiously optimistic. And so I welcome more criticism and input from anybody who has ideas about what should come next in the series, how we should approach things. and things like that. So again, thank you so much to those who invited me to do this, and I look forward to hearing from participants. Any questions, I'm happy to answer.
Hi all, this is Jake Mazetas at ACS again. Just a reminder, if you want to submit questions via text, you can do that using the Q&A app at the bottom. And then also, if you'd like to ask your question live on the air, if you can raise your hand, then I can grant you permission to talk, and then you'll be able to ask your question directly. So please feel free to submit questions. And then Professor, would you like me to read the questions to you, or do you have access to the text submitted ones?
So let me see, Q&A. Okay. I have access, so
Perfect.
I suppose. So I'm just so delighted, Jake, that I actually made it through this spiel without my internet going out. One of the participants, this is a great question. How are the authors of the opinion chosen? So we put out a call for papers, public call for papers, got applications in which people were basically, it was a pretty complicated algorithm. They were asked which opinions they wanted to rewrite. They were asked to tell us why they felt that they should be chosen to write that opinion. And they were offered the opportunity to give some background on themselves in terms of diversity, to allow us to keep our commitment to having an equal, diverse volume. So the CFPs went out, the applications came in, and then with the mother volume, the series editor, the three of us, Bridget, Linda, and I got together and kind of made a spreadsheet. You know, here's who wants to do this opinion, here's why they're, you know, here's why they think they should be, and then, you know, how many people, you know, how many people of color do we have? How many different genders do we have? How many people outside the law professor academy do we have? We reached out to attorneys, we reached out to people outside necessarily the law academy. We had some political scientists. And so we really tried to juggle all of those factors in choosing the authors of the opinion. Great question. Another question. Did you provide the women justices from the U.S. Supreme Court, and did you hear any comments from them? So, you know, I keep meaning to send the books to them, and we have not done that. So that is definitely on my list of things to do, because we really would like them to see and get feedback from them. In the English version of Feminist Judgments, Lady Hale, who is one of the preeminent women judges in the House of Lords, is very, very involved with the project, and we have been less successful, I guess, in getting judicial attention on the project, and that's probably partially our fault, but we are kind of knocking at various doors, trying to talk to judicial audiences about the project, and have so far not been super successful with that, but we are going to keep trying. Do you have plans to continue the project with more opinions? Yes, absolutely. Like I said, the series projects are at various stages of doneness. Tax is the only one that's out in actual physical form. Family law and reproductive justice coming soon on the heels. Torts and employment discrimination are also, the manuscripts are done. They're just in the publication process. And we continue to look for people approaching us about ideas that they have for various areas of law that they think should be addressed. And it's at this point a little bit more random than I would like to admit, but I have to be honest with you that it's mostly people meeting us at conferences, giving talks like this. And, Kathleen Kim, I met at a conference and came up to me and said, "You need an immigration volume." And I was like, "Great." go with it. So that volume is now in the works. So it's at this point now people approaching Bridget, Linda, and I with ideas, and we absolutely welcome them. So.
All right, any other questions, please feel free to submit or to raise your hand. And like I said, we can kind of allow you to talk live, which would be an exciting attempt to use that feature on Zoom. Yeah, exactly, exactly.
I will also say that sort of like the first attendee who asked how the authors were chosen, I should actually talk a little bit about how the opinions were and are chosen as well. You know, when the three of us got together with the mother volume, we were very much thinking, you know, we don't want this to just be, we choose the opinions and that's how it's going to go. So we did this process of putting together an advisory board of very, you know, just scholars basically across the country, constitutional scholars, Title VII scholars, and we gave them a survey monkey, and we sort of went through all the con law books, all the gender and the law books, and plucked out about, I think we had originally about 66 cases, and then the advisory board enabled us to whittle those down to the 25 that we ended up with. And that's really the process that we've done with the series as well. Most of the series volumes have advisory boards. They're chosen very carefully based on, you know, expertise and diversity and lots of other considerations, and then they essentially vote on the cases that should be rewritten. Have we heard from any women's bar associations or any of the national bar associations like the American Bar Association, the Guild, etc.? Not really. We got some attention from the media and from the ABA Journal at the very beginning of the project. But to be honest, I take some responsibility for the lack of publicity, but the book was published, and then a few months later, the 2016 presidential election happened. So we were somewhat overshadowed by other world events. And so it was really hard after that to get people to care about feminist judgments, which I was really a little surprised at because of the incredible impact that President Trump has had on the federal judiciary and the Supreme Court. But no, I guess the answer to that is we've had less attention than we would like.
Professor, if no one else, I have a question for you as someone kind of deeply interested in the theoretical underpinnings of feminism and kind of the world of scholarship around it. So I know that you said that you all have a fairly expansive view of what feminism is as it relates to these judgments, but I'm curious, kind of when you're looking more broadly at feminism in the legal perspective, what is the interaction with theory that happens in that space? Like what do you see as kind of the main tenets of legal feminism, and what traditions might we draw those from in kind of the theoretical world?
So, I mean, I think the first answer is that this project, the whole goal and purpose of the project was to take that theoretical feminism and get it into a form that was more palatable, I guess, to the practice of law. It was in, sort of legal language as opposed to academic language. So if a lot of this is covered in the introduction to the main volume, but you will see multiple different theories of feminism represented in the book. So there's, like I said, intersectional feminism, there's anti-essentialist feminism, there is anti-stereotyping doctrine, there is separate spheres. You know, I don't happen to be a cultural feminist person, but there is a lot of that popping up also in the opinions, you know, citations to Carol Gilligan and the like. So I think that one of the things that was interesting to all of us who edited the volumes is both how broadly feminist theory was represented in the opinions. Like, I don't know that you could find a feminist theory that didn't pop up in at least one of the opinions that we've done, but also how sort of consistently there were common themes that went through the volumes, like, you know, intersectional feminism popped up a lot. You know, anti-essentialist feminism popped up a lot. Anti-stereotyping popped up a lot. You know, structural feminism popped up a lot. Dominance feminism. So I think in some ways the books are meant to be, let's let theory talk to practice in a way that maybe it doesn't very often. And so I don't know if that's answering your question, but that's very much a grounding of the project. You will also see, if they were available at the time, you will see feminists cited in the opinions. Angela Onwuachi-Willig, in her rewrite of Meritor, cites Michelle Alexander. You know, other people cite Catherine McKinnon. So it's a way of integrating the theory into the practice and to show that feminist theory is not inconsistent with practice. It's just another perspective on what the law should mean.
Perfect, thank you. I'm going to try to grant access to Molly, who I see is on the line. Molly, you should be unmuted.
Can you hear me?
Yes, we can hear you.
Hello, everyone. Mostly I wanted to give you a chance to test out the raising hand feature, so I'm glad it works. But I have really enjoyed this conversation and did a lot of work on feminist jurisprudence as a law student, so I'm really excited to hear about this project. And I'm curious whether in the opinions themselves or just in your conversations with authors and your advisory board, if there were conversations about kind of the difference in not just in how issues are viewed, but in how thought processes are different and how a female perspective informs an understanding of the law in a different way beyond just females or women being the subject of whatever the specific case is about.
So yes, that is something that was absolutely discussed. But, you know, we struggled with this idea that a female perspective is somehow different, and we're very careful in all the volumes to emphasize that what we were talking about was a feminist perspective as opposed to a female perspective. Now, is there, in our Venn diagram of those two things, is there overlap? Yes, of course there is. There's lots of overlap. But we also had, you know, like I said, authors who self-identified as gender fluid, who were are male, and I like to think that one of the lessons of the project is that feminism, at least as we conceive it, is not the province of only women or females. And, you know, I chose Bradwell and Johnson specifically today for this audience because it happens to be what I'm thinking about these days. But often with audiences, I will choose specifically one or two of the cases from the volume that talk about masculinity theory. Onkale, Anne McGinley's rewrite of Onkale, which is the same-sex sexual harassment case, as well as Michael M. is another rewritten case in which we really explore this idea that gender stereotyping hurts everybody. It's not, you know, it's not only women who are hurt by this, but also men who are non-conforming or even men who are conforming, but who may feel constrained by those, you know, social rules. So, you know, we talked a lot about that. And again, you know, we didn't tell our authors how to deal with that, but wanted the volumes very much to have that openness to them.
That's really
did that help, or?
Yeah, very much so. Yeah, thank you.
And Professor, I think there's one more text submitted question that we can use to wrap up the.
It's at the bottom. Let's see.
Sorry, is there also someone else raising their hand?
Okay, so the question at the bottom here is, are there feminist judgments that have rewritten opinions written by female justices? And the answer to that is absolutely yes. Sort of this is kind of consistent with Molly's question as well. Like we saw opinions by female justices as absolutely fair game for us because, as many of us might know, not all women are feminists, and even women who are feminists, it is possible to take a different perspective on the case. The other thing that I should say, and I will answer Peggy's question explicitly because she asks which ones were rewritten, that the opinions that we rewrote from from female justices, we were not as constrained as they were, right? So when Justice Ginsburg or Justice Sotomayor or Justice Kagan or Justice O'Connor wrote an opinion and it was a majority, they were required to recruit their colleagues, and we were freed from that, mercifully. So I think that gave us a lot more freedom than the actual female judges and justices have. That said, in the original volume, United States versus Virginia, which famously was decided by Justice Ginsburg, was rewritten actually by the woman who litigated the Citadel case, which provided a really interesting perspective on the opinion. You know, and none of that is meant to criticize Justice Ginsburg. Again, I'm sure she was incredibly constrained by having to recruit her male colleagues to join that opinion, but we had greater freedom to talk explicitly about VMI's approach to education. And, you know, US v. Virginia for me is a very tough case because, again, it was sort of one of those, and I'm making air quotes with my hands, is the right answer, that, you know, VMI really shouldn't be limited to only men. But because of the narrow way that the opinion was written, you know, VMI, I think, it's been what, a couple of decades since that decision was made by the US Supreme Court, and VMI is still overwhelmingly male, because they haven't been required to change the way they do business. And so it's still an incredibly unwelcoming environment for girls. So there was United States v. Virginia. The other case in the Mother volume, rewritten, that was written by a female justice, is Gebser v. Laga Vista, which was written by Justice O'Connor. And Gebser, for those who don't remember or know, is a Title IX case in which a young girl was statutorily raped over a period of years by her male teacher. She was, I think, 14 and he was 50. And the court decided in that case that she could not recover under Title IX because there hadn't been sufficient notice to the school district to have them be liable for the Title IX violation by their teacher. And the rewrite of that opinion is also very, very interesting. It does mainly rewrite the facts, because if you look at the facts of the original Gebser, the court talks about the child and the teacher as having had kind of a romance. And the feminist judgment really takes issue with this. And obviously also with the legal reasoning that somehow a 14-year-old is supposed to go up to the school administrator and report this behavior. She did report it to another teacher. She reported it to various people within the school, but they were not high up enough to give the school board notice of the violation, according to the court. So those are the two that spring to mind from the Mother volume. I think there are probably others in the series volume, but I'm afraid that I can't remember them right now.
All right, well, Professor, we want to be respectful of your time and make sure that everyone else is able to get back to their day, but thank you so much for joining us today. I know we really enjoyed hearing from you, and you've given us a lot to think about as we have nothing to do kind of but sit at home and think during these times, so definitely appreciate it. April, I don't know if you want to add anything. We've got an upcoming ACS At-Large event on April 17th that we hope you all will join us for, but April, I don't know if you want to wrap up with any closing comments.
Well, I just wanted to say thank you to Professor Stanchi for giving such a wonderful talk. I had several questions, but I really wanted everyone to get their questions out there. They were so enlightening to me, and your responses were very thoughtful. I really appreciated that. So thank you.
Oh, I'm so appreciative of the invite. Thank you so much. And April, you can email me your questions. I'm happy to talk to you.
All right. Oh, perfect. All right. Thanks, everyone. Have a great rest of your day.
We'll be sending an email out, right? Oh.
Yes, we can definitely send a follow-up email.
Okay, great.
All right. Talk to you all later. Bye.